yeah, how do I enforce it? How much does enforcement cost? Is it even worth getting it if it's going to cost so much to enforce? So that's a really common concern. And there's sort of a school of thought out there, which I think is really a myth, that patents aren't worth getting at all unless you're Apple or Google and you have $1 million to spend on enforcement lawsuits. So I disagree with that point of view, obviously. But no, I really do, truly, because I think what it does is it's taking Google and Apple and sort of pretending that that's every company. And that's the only way to enforce patents is the way they do it. Well, that's ridiculous. I mean, most companies don't do anything the way Google and Apple do, or at least, not on that scale. So their enforcement doesn't have to be on that scale either. So let me tell you a little bit about how typical enforcement situation works and what's really involved in enforcement, and maybe that'll help kind of clear up some of the misconceptions. Typically, enforcing a patent or a trademark, but especially patents, it's really about the end result from the whole thing is typically a license agreement, a license deal. So it starts with, if you find or we find, depending on how you want to work the enforcement. But if you find, let's just start with that. That's fairly typical. If you find that someone is infringing your patent, and this would be a granted patent, you can send a letter to them, and that's the way it starts. It's just sending a letter saying you're infringing my patent. I have a patent on this. They call that a cease and desist letter, but it doesn't have to be a super aggressive, we're going to sue you cease and desist letter at that stage. The better approach, and the approach that we take, is to make that first letter an invitation to open a dialogue to talk about licensing the patent. And we actually just did one of these for a client who and the infringer on the other side was very interested in the opportunity to license this patent. And then at that point, they can say that this invention is patented, so that they get a benefit, and they get that benefit in exchange for paying our inventor a royalty. So this was an infringement situation. We sent the letter to open the dialogue saying, this person has a patent and you're infringing that patent. And instead of a lawsuit, what's coming out of it is a license deal where our client will get a royalty from this infringer. That is the typical way that this happens. As you might imagine, it doesn't make the news. So it's invisible to a lot of people. And that's why they have this idea that, if it doesn't become like $1 million lawsuit, it's not worth, there's nothing else. That's all there is. That's not true. Plenty of patents are enforced this way, with a letter that ends up in a license deal. If they're a little more, dug in and they're not open-minded to that, maybe we might have to send a little nastier letter and then maybe even file a lawsuit. But even then, it's not, $100 million to file the lawsuit. It's just like any other lawsuit. And typically, there are points after the point at which the lawsuit is filed where people will, you'll have the opportunity to reach a settlement, and the settlement, surprise, is usually a license agreement. So whether it happens, this is one reason why it's good attorneys on the infringer's side will recognize if there really is infringement here, it will save everybody a lot of money to just enter into a license agreement earlier, and start making money together. Why pay lawyers to fight about something if the end result is going to be the same? And so that's the typical way, the typical outcome from enforcement scenarios for patents. So I hope that helps allay your fears a little bit. If you don't have a patent, you really have nothing to license. So unless you have trade secrets, that's a whole other conversation.